All right, good afternoon. My name is John Peskin. I'm the hearing officer assigned to this matter. This is 1906-00531 in the matter of changes to the rules and regulations of the Oil and Gas Conservation Commission of the state of Colorado. So I wanted to give a brief outline. First of all, I'm John Peskin, the hearing officer. This is Mimi Larson, the secretary of the commission. We've got James Rouse over there, hearings manager, and Elias Thomas, who is also another hearing officer, but I think they're just here for moral support. So I want to just give a brief outline of what we're going to do today and how this is going to work so everybody has a clear understanding. We're going to start off with the roll call, and we're right around 70 odd parties roughly. I haven't done an exact count, even though I have everybody's name and information now listed on a spreadsheet, which we will upload to our website later this afternoon. We're going to start with the roll call, see who's here, who's on the phone. After that, we're going to talk about the scope of the rulemaking. After that, we're going to talk about potential consolidation of parties and interests. And then we're going to finish with any questions about our process. So that's what this afternoon is going to look like. We've got 2 hours set aside. Not sure how long this is going to take, but let's get started. So I think the easiest way to do this for the roll call is for me to just read the party name, and you can go ahead and state your presence, however that looks. All right, 350 Colorado. Okay. Adams County Communities for Drilling Accountability Now. Adams County Board of County Commissioners. By the way, can the people on the phone hear me?
Yes.
Okay. Anadarko.
Yes.
Okay, Anadarko's here. Anthem Ranch Community Association Board of Directors. Associated Governments of Northwest Colorado.
Present.
Thank you. Augustus Energy Partners. All right. Barrett Engineering. Danette and Charles Barrett. Bayswater Exploration and Production. Be the Change. Connie Beach. Barbara Binder. Boulder County. Broomfield Concerned. Broomfield Health and Safety First. Broomfield Moms Active Community. City and County of Broomfield. Citizens Advocate. Citizens for a Healthy Community. Climate Reality Denver Boulder Chapter. West Slope Colorado Oil and Gas Association.
Present.
Town of Colbrand.
Present.
Colorado Alliance of Mineral and Royalty Owners. Colorado Coalition for a Livable Climate. Colorado Environmental Advocates. Colorado Oil and Gas Association. Colorado Petroleum Association. Colorado, oh. I'm going to ignore you, Mr. Parrott.
Thank you.
All right. Colorado Petroleum Council / American Petroleum Institute.
Here.
Oh, Mr. Parrott's here
A
again.
little early.
Colorado Rising. Colorado Sierra Club. Confluence, DJ. ConocoPhillips.
Here.
Conservation Colorado. City of Craig.
Present.
Thank you. Crestone Peak Resources.
Here.
Delta County.
Present.
Gotcha. Christy Douglas. Patricia Dunn. East Cherry Creek Valley Water and Sanitation District. Energy Council. Did somebody raise their hand?
Present.
Oh, you're on the phone. Gotcha. Erie Thriving. Extraction Oil and Gas.
Present.
Firestone Mineral Holdings, LLC. Front Range Residents for Environment, Safety, and Health. Garfield County.
Present.
Grand Valley Citizens Alliance / Battlement Concerned Citizens.
Present.
Great Western Operating Company and Grizzly Petroleum Company. Gunnison County Board of County Commissioners. Ella Heitman Estate, Colleen K. Heitman, Personal Representative.
Here.
Jackson County.
Present.
James Kettler. Sarah Kettler. Vicky Kettler. City of Lafayette. League of Oil and Gas Impacted Coloradans.
Present.
Lookout Alliance. Magpie Operating.
Here.
Medical Symposium Educational Group. Town of Meeker.
Present.
Mesa County.
Present.
Judy A. Myers. John L. Myers. Moffett County.
Present.
Montezuma County.
Present.
J. Gale Moody.
Here.
Morning Gun Exploration. Mothers Out Front. Town of Newcastle.
Present.
Nickel Road Operating. Susan Noble. North Range Concerned Citizens. Oil and Gas Education Group. Oak Creek Oil and Gas. Town of Parachute.
Present.
PDC Energy.
Here.
PSR in Colorado. Town of Rangeley.
Present.
Residents' Rights. Rio Blanco County.
Present.
Joseph P. Rock, Jr.
Here.
Safe Superior Citizens Action Group. David and Rana Sanchez. Sandridge Exploration and Production. Deborah J. Shannon. Town of Silt.
Present.
Terra Energy Partners, LLC, and TEP Rocky Mountain, LLC.
Here.
City of Thornton. Thunder Ridge Resources.
Here.
Together Against Neighborhood Drilling. Top Operating Company. Ursa Operating Company. Randy Webb. Wise Consulting. Weld Air and Water. Weld County. Western Colorado Alliance.
Present.
Western Slope Conservation Center. Westminster Community Alliance for Protection and Empowerment. Wildgrass. Okay, is there anybody I missed?
Adams County is here.
Boulder County is here on the phone.
Adams and Boulder, you were late.
Just missed it.
Okay, I'll allow it this time. Hold on one second. Yes, sir.
Baskin, did you call Firestone Mineral Holdings?
Yes,
Apologies, I missed that one.
that's okay. Firestone Mineral Holdings LLC.
Yep, thanks.
Sure. I've got Adams County and Boulder County are both on the phone. Is that correct?
Yes, sir.
Okay,
Correct, thanks.
sure. All right, is there anybody else that's been missed? Yes. City and County of Broomfield. And what was the other one?
City of Lafayette.
Lafayette, okay. Okay,
Baskin,
Yes.
a clarification question.
sure.
James Barrett here for CPD. May have misunderstood, but is there an implication that if a party is not here, they are no longer a party?
We are not taking that position.
Okay, thanks.
You're welcome. For the people on the phone who may not have heard the question, the question was basically, is attendance at this initial pre-hearing conference mandatory in order to retain party status? And the answer to that is no. Does anybody on the phone have any questions about that? Okay. So we've just done roll call. I want to talk about the scope of today's pre-hearing conference. We're here to talk about the amendment to the 500 series rules. The scope of this rulemaking is basically to amend the 500s in order to facilitate administrative law judges and hearing officers being able to consider what was previously the exclusive jurisdiction of the commission. We understand that people have additional concerns beyond that, but we want to reiterate that that's the scope of this rulemaking. So the next step that we want to talk about is consolidation. And consolidation, we don't have as many what I would call consumer groups present as I hoped, but I'm sure that industry, this could benefit industry as well as local governments, but we're encouraging people who have similar positions to consolidate their positions in the interest of time, in the interest of presenting facts and statements to the commission at the June hearing. Right now, just given the sheer number of parties we have, there's no way that people are going to have the time they want to make their statements at hearing in June. So if we could get groups to consolidate their positions and consolidate their statements, we would highly encourage that. We might be able to allow a larger time span for a position at that point. So we obviously can't force you to do so, but it would be in your own best interests. That information, as far as the groups that are not present, particularly the consumer groups, the consumer advocate groups, we will do what we can to convey that on our website as well, to try to get people to just come together and share their perspective in terms of being more efficient. So there will be a CMO issued later today. The CMO will have, I know we've been asked this question by a couple of different individuals. The CMO will address things like page limits, spacing, font, et cetera. I just remembered something else. As far as, there's not that many individuals here, but we wanted to let people know that they have the opportunity, if they choose, to go the 510 route rather than necessarily having to maintain a party status standing. So if a person or entity is interested in the 510 route, obviously that would mean that they're relieved from their obligations under the deadlines that we put on our website. They wouldn't be bound by the deadlines in the CMO that's going to be issued later today. they would be able to submit a written statement that would go to the commissioners. It would be part of the record. It'd be given no more or less weight than if they were to make a statement as a party. So we have not updated the website to reflect the deadline for the 510 statements, but we're going to do that today as well. So to the extent that we can spread that information, we would appreciate that. Because I know some people, we've heard as recently as the hearing yesterday and at the stakeholder meeting we had last week, that it's difficult for individuals to get here, to take time off work, things like that. So we're not going to force anybody into a 510 route, but if they want to go that route, there's absolutely nothing wrong with that, nothing preventing them from doing so. So to the extent there are, the individuals listening and the consumer groups listening, you can direct all your questions to me, not Mimi Larson, but to me as the hearing officer on the matter. My name and email address is actually on the party status form that's on our website. I know Mimi's been getting a lot of questions directed to her inbox. Those probably should be coming to me. So if anybody has any questions about the differences between 510 and maintaining party status, I'd be happy to address them. Okay, so that being said, do we have any questions about the process for this rulemaking?
Got a question.
Mr. Petrala. Consolidation, go ahead.
So if two parties decide to consolidate or have one representative, how are you going to allocate time? Are we essentially giving our time over to that other party, or is time lost?
So the question, in case you couldn't hear it on the phone, was in the event that parties decide to consolidate, what happens to that time? Is the time being relinquished to the other? Just to clarify, Mr. Petrala, are you saying if you're A and you want to consolidate with B, does that mean A's time is gone?
That's the question. That's where A's time goes to B, so that B gets double the time.
Well, number one, we don't know what the scope of time will look like until we have a better idea of who's consolidating, right? So if we still have 70 individual statements that want to be made on the record, that's going to be a scenario we'll have to evaluate, as opposed to if we have, say, 20, right? Which will obviously dictate the timeframes that those 20 parties get as opposed to the 70 parties. But I would imagine, I mean, my guess would be that if you are A and you want to consolidate with B, you would work on a joint statement and then your times would become one. Does that make sense? In other words, A wouldn't have their own time anymore. B wouldn't have their own time. They would have a joint amount of time based to be determined, because we don't know what that's going to look like yet. But I would imagine that your statement, if it were actually made by B, that you would have had some input into that statement. I've never known you to not stand up for your own position or speak your piece. Does that answer your question?
Not entirely.
So-
I guess we just need to wait and see how this plays out.
Yeah, and I don't know if you want to make a comment, Ms. Larson.
Yes, this is Mimi Larson, the Hearings and Regulatory Affairs Manager. So just to add a little bit to what Hearing Officer Peskin was saying, certainly if parties wish to continue to file their own individual pre-hearing statements, and then after those pre-hearing statements have been filed and in reading other parties' pre-hearing statements, common themes are emerging, and for instance, citizen groups decide to come together as one block that wish to make a presentation in front of the commission at the rulemaking hearing. Various industry representatives decide to come together as one or two blocks, or however this may work, local governments, similar fashion. That may be a rather elegant way to ensure that all the arguments are heard and that discrete interest groups have sufficient time to put on a larger presentation than if we just try to accommodate 64 individual presentations, which, to be honest, the time is going to be incredibly short for each party if that's the case. So,
Mr. Parrott.
I'd like to follow up on Mr. Shaw's question for James Parrott for CPC. This is a comment, not a question, but in past rulemakings, the commission has utilized certain policies to encourage consolidation, such as granting more time to consolidate it through. So I'd like to leave you with that comment to do with it what you wrote.
Thank you. Does anybody on the phone have any comments or questions?
Just that what Mr. Parrott asked is a good comment, and be good to understand that process of allocating time. If we, I mean, maybe I'd join 14 parties together.
Is this Mr. Nguyen? Okay. Yeah, I mean, that's, we agree. We agree with that policy. Now, again, we can't say today what that's going to look like because we don't yet know who's going to consolidate, but we are encouraging it. And I can't state it better than Ms. Larson just did, but if we can, we understand that there's going to be, not every local government is going to agree with every local government. There's going to be some diametrically opposed views there, but to the extent that you can consolidate and utilize a larger block of time, that would be our goal. But we'll have to wait and see what transpires over the next couple of weeks in terms of what we get filed, the requests we get filed for consolidation and things like that. Yes, ma'am.
Steve Ardell for Camera. I have a question regarding scope. You mentioned that the scope is limited to the inclusion of ALJs, hearing officers, although the statement of basis and purpose speaks to revision of 500 series to include 181, and there are other revisions in the rules, in particular of interest to Camera. We want to make sure that this is the appropriate venue to raise the issues, particularly, I would say, around Rule 530.
Yeah. Oh, go ahead, Mimi. Yeah.
I would just say, I mean, yes, certainly the 500 series, the bulk of the edits and proposed amendments relate, as Hearing Officer Peskin stated, to the administrative law judge and hearing officer process. There are discrete amendments to Rule 530 as it relates to pooling to incorporate 181's statutory changes to pooling, and then also the evidentiary provisions under Rule 511 for drilling and spacing units. So it's limited to just those discrete amendments. This is not, however, the additional 10 rulemakings that will, or 11 rulemakings that we will be working through over the course of the next 14 to 16 months that implement the remainder of 181. So as it relates to public health, safety, welfare, and the environment, flow lines, all those other rulemakings will follow.
This is the one for those particular pieces.
That is correct, yes. So Rule 530 and 511 as well, yeah.
Yes, sir.
Mark Matthews for COVID. Do you anticipate any further revisions to the 500 series before the hearing?
You know, certainly we'll have to see what pre-hearing statements provide, what information is provided there. At this point, we don't anticipate any changes from what we've noticed and what is on our website. But again, we'll see what the pre-hearing statements come back with.
Does anybody on the phone have any other questions or comments? Yes, sir.
Question, James Barrett for CPP. Is the CMO going to include pre-hearing motions and deadlines?
Yes, I don't know what types of motions may be filed, but it will lay out the deadlines and the groundwork, the rules as far as page limitations, all of that for pre-hearing statements and responses. We're not allowing replies. I can't imagine what motions may be filed, but file away.
Thank you.
You're welcome. Does anybody have anything else?
One final question, then I promise I'll leave.
I have a lot of witnesses to that statement, so go ahead.
Thank you. Are you going to publish a list of parties? Consolidated list of parties?
Yes, that's what I have right here. This was done just minutes before this pre-hearing conference started. This will be on our website today.
Thank you.
You're welcome. If anybody on the phone did not hear that, we will be publishing a list of all of the parties that have been granted party status on our website today. And in case people are not aware of where that information is, if you go to our homepage, there's a tab that says SB 19-181 on the far right and the header. When you click on that, it opens a blue header beneath it. It says Rulemaking. When you click on Rulemaking, that's where all of this information is. And there's links at the bottom of that page that if you click on, it takes you to a Google Dropbox sort of place. And that's where we're keeping all the documents. So again, maybe some of the consumer groups could spread that information. We're getting a lot of questions about where these documents are located. So if that's it, nobody has anything else going once. Anybody on the phone? Okay, that's going to conclude our initial pre-hearing conference. Thank you very much, everybody.